The Supreme Court takes up a new Second Amendment case for its upcoming term. Plus, the Trump administration begins rolling back a Biden-era gun rule. All this and more on the news update.
No, the devil's got no hold on me.
All right, ladies and gentlemen, welcome back to the news update. I'm contributing writer Jake Fogleman, joined as always by Reload founder Stephen Gutowski. TheReload.com, of course, is where you can head on over today to sign up for our free weekly newsletter. It'll keep you up to date on all things happening in the world of gun politics and policy. Kick things off for us this week, we have actually a little bit of breaking news that just dropped. We're recording this Friday morning, and we got this news, actually just minutes before we started the show here. And that is that we have our first Second Amendment case of the upcoming Supreme Court term. This morning, the U.S. Supreme Court granted certiorari in the Walford v. Lopez case dealing with Hawaii's Bruin response bill related to sensitive places. Although what the case that the court is going to hear is a little bit narrower than that.
Yeah. We finally got some action from the Supreme Court on the Second Amendment. I mean, finally, right, this stuff's all relative.
Sure.
The
court years versus human years.
Exactly. The courts. Yeah. This has been a lot of Second Amendment cases, I suppose, if you look at it historically, especially since they didn't really do any Second Amendment cases until 1937, I guess, Miller. This is a pretty good pace if you take a really broad view of things, but obviously not the pace that a lot of gun rights activists have been wanting. And so we now have a new Second Amendment case that deals. I mean, this is an actual Second Amendment case, not just a gun case, right? We've had some gun cases like the NRA Vulu case, which was really a First Amendment case. It was about Second Amendment advocacy, but it was actually a First Amendment question. But this one is directly dealing with the Second Amendment and whether or not Hawaii's default swap, or what gun rights activists have taken to calling the vampire rule, because these rules that a number of these post-Bruin response laws in some of these deeper blue states have adopted, which essentially, it flips the default assumption to where everywhere else, and for all of history, as far as we're aware, it has been assumed that as long as somebody does not post a no guns sign in a publicly accessible piece of private property, so think, a store or something of that nature, that you're legally allowed to carry inside of the store, if you have a license or otherwise permitted to carry a gun. So these rules that came in and popped up right after Bruin, when a number of states were looking to move from the May issue, restrictive, subjective permitting process that kept most people from being able to obtain a permit, toward a more restrictive, sensitive places based law. You saw a number of states adopt this default swap or vampire rule, and it requires essentially that in order for somebody who's licensed to carry to be able to carry in any private property, publicly accessible private property, the owner has to post a sign or otherwise indicate that you're allowed to carry there before you can do it. And that's why they call it the vampire rule, or what a lot of gun rights activists have taken to calling it that, because vampires can't enter your home unless you invite them in, as we all relearned with Sinners this summer. Great movie, but vampires can't come in unless you invite them in, and that's basically what this rule does for gun carriers, essentially. And so this has fared very poorly in the lower courts up to this point. These Bruin response laws have had a fairly mixed result in the lower courts, where judges are, for the most part, you're getting kind of picking and choosing what sensitive places are allowed. Sometimes it's basically all of them except for this default swap rule. and sometimes you get, okay, these restrictions are okay, but these ones aren't. Actually, the Ninth Circuit in this case, Wolford is the name of the case, Wolford v. Lopez. I think they had, when they ruled on this back in, I think it was September of last year, they struck down a couple of restrictions on like parking lots and financial institutions, and then upheld everything else, including the default swap rule, which was unusual because the majority of the cases we've seen that we've covered have gotten rid of the default swap and kept most of the other sensitive places restrictions. So the Supreme Court is now going to hear this case in the next term, but they did limit it a little bit. So there were actually two questions presented by the plaintiffs here, or the petitioners. One was about whether or not the Ninth Circuit was correct in upholding the default swap or the vampire rule. And the second one was a question about whether or not they were using the proper historical time frame to judge whether or not these restrictions fit in the historical tradition as required by New York State Rifle and Pistol Association v. Bruin, the Supreme Court landmark ruling from 2022. And so the court is only going to hear the first question, and they are not going to decide the second question about, what the proper timetable is for the Bruin analysis, which is kind of interesting, right?
Yeah, definitely interesting that they took a narrow approach. I just want to go back to something you mentioned about the Ninth Circuit's ruling. This Hawaii case that they're taking up is, in fact, the only appellate court that has ever upheld one of these so-called vampire rules. And it's funny, this case in particular actually combined Hawaii's Bruin Response Bill and California's Bruin Response Bill in the same ruling. And they struck down California's vampire rule in the same ruling that they upheld Hawaii's, because they said California's was too prescriptive. It required, it specified the exact dimensions of the sign that store owners would have to publish to allow guns onto their property. And the Ninth Circuit, for some reason, said that's not okay. But generally, flipping the default is okay. And other interesting thing of note in this case is, if listeners will recall, this is the first one that the DOJ actually intervened on behalf of gun owners to ask the Supreme Court to take up this question, even though it's not a party at all to this case. So a little bit interesting there to see that perhaps the DOJ, under the Trump administration and under its pro-Second Amendment sort of posture that it's been ordered to take, could be paying some dividends for gun rights advocates, depending on how this case turns out.
Yeah, the DOJ has been, I guess one way to put it is very successful in influencing the Supreme Court to this moment through the second Trump administration in a lot of different cases, sometimes to the surprise of a lot of people in some ways. But yes, this suggests that perhaps the DOJ is going to have influence in some of these cases where they're intervening on behalf of gun rights plaintiffs. So good point. It's interesting that they didn't take up that second question too. It sort of suggests as well that they maybe don't have a consensus view yet on when the cutoff for this historical test is supposed to be, because I believe in this case, a lot of the analogs they found in state laws came from after Reconstruction, so after the ratification of the 14th Amendment. And that's been a question that Barrett has openly said in a concurrence, I believe in Rahimi, that the Supreme Court needs to answer, and they haven't done that. And now they're still not going to do it, which suggests perhaps they don't have a broad agreement on that point yet. The first question, this is another one where I wouldn't be shocked if this was unanimous. Because it depends on how the liberals on the court are feeling on this one. But we saw, as we're going to talk about in a moment here, the Supreme Court was unanimous in another gun case the last couple of gun cases, they've been unanimous, right? The NRA one that we mentioned earlier, the Vulu case, which was really a First Amendment case, but dealt with Second Amendment advocacy. And then also the Smith & Wesson case, the Mexico case against Smith & Wesson and other American gun manufacturers. They were unanimous there too. Again, they didn't get to any Second Amendment questions, but another gun case. And I could see this one being unanimous, perhaps because of the fairly narrow question being asked, which is just whether or not this default swap, which really, as far as we can tell, has no, as far as, from what we've seen in these cases, there's not much historical precedent for this. There's historical precedent for, banning firearms from private property that isn't open to the public, right? That isn't generally open to the public, but the way every state, it seems, that has done this regulation over the years has been the opposite of what Hawaii is doing in this case, which is to say, you can certainly ban guns from your publicly accessible private property, like a store or what have you, but you have to post signs that say no guns allowed, right? So it'll be interesting to see what the liberals decide to do. Sometimes I think, there's obviously some maneuvering that goes on in these cases. And sometimes if the liberals think that it's not worth putting up a fight on these lesser questions, they might want to be the ones to write the opinion so they can shape what gets said here. And so maybe that'll happen in this case. Obviously, we're a long way out. We haven't had any indication from the court exactly where they're going to go on this. We don't have oral arguments or anything to go off. So just that's one, I guess, just kind of wild speculation on my part here right on the day of them accepting this case. But given how it's gone in the lower courts, where even the liberal-leaning circuits have essentially all struck down this law, except for this one case. And just them taking up this case implies that they want to reverse the lower court. That's often what happens, right? They're not usually taking up cases where they're going to affirm the lower court. But so those are the first insights, I think, that we've got on what's happening here. But speaking of the Supreme Court, we have another story that deals with the fallout of a recent ruling, that one of the ones we just talked about, right?
Yeah, just teased it in the last segment a little bit there, but the fallout of that Mexico case, which dismissed a challenge on the grounds of the Protection of Lawful Commerce and Arms Act, which is, of course, the contentious liability shield that the gun industry gets that prevents them from lawsuits that are on the basis of crimes committed with their products by third parties that they don't have a direct, link to. They don't directly break a law to help that person commit their crime. Because of that ruling, we've now seen judges have to reverse themselves in past cases. And in particular, this one that you wrote about has to do with a case in Vermont, which is interesting because it's a case in Vermont about a crime that was committed in California, of all places, dealing with gunmaker Century Arms. And a district judge is reversing himself in that case because of the Supreme Court.
Yes, this case deals with the 2019 Gilroy Garlic Festival shooting, where the shooter had legally purchased essentially an AK, or actually I guess it's like an AR-10 variant, WASR-10, which was a Century Arms firearm. He bought it from a gun dealer, obviously, in Nevada, where it's legal, and then took it into California, where it is not legal for him to possess, and then he carried out the attack. And so the lawsuit is actually very similar to the Smith & Wesson lawsuit in that the plaintiffs, who were survivors of the attack or the family members of the victims, they alleged that Century Arms had essentially oversold these rifles, the number of rifles in Nevada, with the understanding that some of them were going to be trafficked illegally into California, and therefore that knowledge, they weren't accusing them of directly knowing that people of an actual gun smuggling or trafficking ring. They're just sort of like in the Mexico case, it's just sort of the general knowledge that some people do traffic firearms from Nevada to California was the issue, that they didn't impose some additional restrictions beyond what is required by law makes them liable for what happened at this in this shooting. That's sort of the idea at play, that they aided and abetted the shooter through a sort of systemic overselling of their firearms in Nevada. It was the legal theory here. And initially, the judge, in this case, Judge Sessions, had said that was enough to overcome, to make it through the early stages, at least, of this kind of lawsuit. And that's where a lot of these suits are fault. A lot of the key points, because of the Protection of Lawful Commerce and Arms Act, doesn't allow, as you mentioned, certain kinds of liability lawsuits against gun dealers and gun makers. And so a lot of the fight is over whether or not the pleadings fit into certain exceptions in the PLCAA. And that's what the Mexico case was about as well. It wasn't close to the merits. It was just about whether or not they'd pled a viable claim. And, so initially in December 2024, the judge here said that they had, but then in June, the Supreme Court handed down its ruling and essentially came to the opposite conclusion in the Smith & Wesson case. So this judge has gone back now and changed his view to line up with the Supreme Court. And here's a quote from the case. It's called Towner v. Century Arms. It says, "Plaintiffs have not plausibly pled that the firearms violation in this case, illegal possession in California, was individually or systemically aided and abetted by the defendants, such that the plaintiffs could satisfy the CAA's predicate exception. Therefore, plaintiffs' claims as pled are barred by PLCAA." So, he essentially said this case is very similar to the Supreme Court's Smith & Wesson case, and I'm bound by that, so I have to reverse myself because, after the Supreme Court articulated some of what's necessary to show an aiding and abetting claim under the PLCAA, this Century Arms claim didn't have a lot of the factors required, and including something like a specific actual crime. Like there was no evidence that the sale to the shooter in Nevada was actually illegal in any way. And also, Century Arms didn't sell this gun to the shooter. A gun dealer in Nevada did, but the gun dealer, just like in the Mexico case, the plaintiffs didn't allege any wrongdoing by the people who actually sold the guns. They, were going after Century Arms itself, which is several steps removed from the actual purchase. So that was another major issue that he noted in this case. And so, you're seeing the effect of that unanimous Supreme Court decision already down in just a couple months after the Supreme Court issued its decision in the Smith & Wesson case.
Yeah, certainly interesting to see, especially as, attempts to circumvent the PLCAA by gun control groups and trial lawyers and victims of mass shootings that have really ramped up in recent years. So it's interesting to see the practical effects on those types of lawsuits in light of that Supreme Court ruling, which was the first time that the Supreme Court has ever opined at all on the PLCAA. So always something we're going to be keeping an eye out for to see how what the ramifications are down in the lower courts. Moving on to another story we have this week related to the Trump administration's approach to his predecessors' gun control regulations. This one, not an ATF rule, which I think a lot of gun rights advocates are looking for, is some movement on ATF rules, but actually a Commerce Department rule that the Biden administration passed at the tail end of his first term, one that we actually broke some news on because we published the leaked documents of this rule at the time. But we now have reporting that the Trump administration is planning to rescind the Biden administration's export restrictions that it tried to pursue through the Department of Commerce.
Yes, they've actually already submitted the rule undoing essentially the previous Biden era rule. As you mentioned, we were the ones who broke news that this was going to happen, that the Commerce Department under President Biden was looking to restrict gun exports to a number of countries, but several of which are, American allies, where civilians have both newly acquired the ability to buy more firearms. So that would be in Ukraine and Israel. Both of those countries were part of the restrictions here. And both of those countries have seen a liberalization of their civilian gun laws in the wake of the Russian invasion in Ukraine and the October 7th Hamas attack in Israel. So this rule had greatly restricted what kinds of firearms could be sent to those countries. And honestly, it had actually kind of imposed a form of gun control on foreign nationals in the sense that one of the requirements the Biden rule had was that exporters would have to get the identifying information, like ID documents from the end buyers in these foreign countries in order to sell them certain kinds of semi-automatic firearms, which is difficult to do because these exporters are not the end sellers in most cases. They sell to dealers within these countries who then have to follow their nation's laws, which frankly are usually stricter than our own here. So that was kind of an interesting move on the part of the Commerce Department in this case, where they're sort of requiring almost a registry of these foreign gun buyers to be kept by American gun exporters. But the Biden administration said that this was necessary to prevent essentially gun trafficking, because some American-made and exported firearms had ended up in terror attacks or different political violence around the world, and so they claimed that this was these new restrictions were aimed at trying to prevent that. Obviously, the gun industry vehemently disagreed that was an issue or one that would be fixed by the regulations. They claim that this was the Biden administration just trying to harm the gun industry. We talked with some people in the exporting business, and they were concerned about this rule and the kind of impact it would have on their companies. Jordan Young, who owns Global Defense, which is a small gun exporter, he said he was worried that this would eventually put him out of business, essentially. And then, of course, we had kind of an interesting road to this point, because at the beginning of the year, when the Trump administration came into office, they put a total freeze on all gun exports, in addition to a bunch of other exports too. I don't know that it was necessarily targeted at the gun industry, but it certainly had a negative impact on gun exporters, where you just couldn't get any licenses during that time. They eventually rescinded that, and now they're taking an action that has the gun industry is cheering. The National Shooting Sports Foundation released a statement applauding this move, and it is in line with what President Trump had promised during the campaign to, which was essentially to undo all of the executive gun actions that President Biden had taken during his term. And in fact, it's one of the first, actually, now, I guess, that we're seeing them actually do that. We've seen them obviously take action to implement their own updated version of the firearms rights restoration process for felons and other people who've been disqualified from owning guns, but that doesn't actually roll back anything that Biden did, right? That's a separate initiative. And we've seen some efforts in court. We'll talk about one in a moment, but we've seen the administration at times, I guess, settle for letting a court order do the work of eliminating some of the Biden rules, but we haven't actually seen them, especially from the ATF, as you alluded to, put out their own rules to rescind Biden era gun restrictions. The pistol brace rule, the engaged in the business rule, which actually they've been defending in court, as we've talked about recently. And then they just haven't done the work of rescinding these rules yet. I mean, they promised to months ago, and then just haven't yet. So I don't know whether it's coming down the line or what's going on there. We're not sure, but the Commerce Department has moved to undo the Biden era gun restriction that they put in place. Now, they also, by the way, this sounds like interesting to me. They claim that this is going to amount to hundreds of millions of dollars worth of recovered revenue for the gun industry per year on by loosening these or reverting these rules back to basically what they were in 2020. So that's interesting. They sure think it's going to have a major impact on the industry. I guess we'll have to see if that comes to fruition, if it's really going to be that much money. But yeah, it could be significant.
Yeah, that would be interesting to see if it does become a windfall for an industry that is looking for some positive signs, as we've talked about so often on the show, sort of the slump that they're in. So we'll keep on top of that for sure. Which,
by the way, didn't get any better. We got the background check data this week. I haven't written a piece, not sure if we'll have time or not, but the third quarter was down, I believe, 10% year over year in National Instant Criminal Background Check System checks on gun sales related checks. So although September was up slightly, I believe, according to the National Shooting Sports Foundation. So, but certainly not a turnaround by any means.
Last thing we want to talk about from our end on the Reload, and we're just going to briefly tease it because we're going to go into a little bit more in depth on the actual interview podcast. But that is, of course, the big news this week that the DOJ filed its first of its kind lawsuit on behalf of gun owners against the Los Angeles County Sheriff Department over. This is sort of the culmination of that investigation that we covered earlier this year into its alleged practice of repeatedly delaying the issuance of concealed carry permits, sometimes taking as much as 2 years to get people permits after they've applied. And so now the DOJ Civil Rights Division is actively filing suit and claiming that violates the Second Amendment.
Yeah. One of the so first of its kind civil rights lawsuit from the DOJ, where the civil right is the Second Amendment. So that's unique. Certainly going after a police department for patterns and practice of denying gun carry permits. We haven't seen the DOJ do that before. So it's a significant development in that regard. And yeah, we're going to have Costas Moros, who's a gun rights attorney for the Second Amendment Foundation, but also which has its own lawsuit over these delays going. But also he's himself delayed on his permit application. And he, it seems, was perhaps one of the people who inspired this investigation and lawsuit in the first place, because he was publicly advocating for the DOJ to do something like this. And then they did. So we'll have him on to discuss, what he thinks about this suit and whether he's happy about where the administration is going on this.
Yeah, so listeners should check that out. Reload members can get that on Sunday, and everyone else, it'll be available on Monday. But getting into some of our stories from outside the Reload this week, we have a pair dealing with sort of the latest in the will they, won't they saga about Minnesota's special session for gun control. If listeners recall, after the Catholic school shooting up there, Governor Tim Walz basically said that I'm going to declare a special session on gun control. And one of the policies he made sort of the centerpiece of that was an assault weapon ban. Well, that was several weeks ago now, and it seems to be a bit of a holding pattern as to whether or not that actually is going to happen at this point because of the very narrowly divided political conditions in that state.
Yeah, it sure sounds like that might not happen at all, that they simply don't have the votes for something like an assault weapons ban. And it doesn't sound like they've made much progress in finding some sort of other common ground on how to respond to this shooting legislatively. Interestingly, though, Walz has now pivoted to suggesting perhaps a constitutional amendment to the Minnesota Constitution that would, I guess, address the issue, which obviously that, it seems like that would be a higher bar to accomplish beyond just passing legislation in normal order. But Minnesota does have a fairly low bar for constitutional amendments, I guess like some other states do, where essentially you just need, I think, a majority of both houses to present the question to voters, and then you just need a majority of a ballot initiative to amend the Constitution. So maybe there'll be some, I guess the idea would be maybe there's some politicians in Minnesota who are willing to vote to let the voters decide the question rather than vote on the policy itself or vote for the policy itself. So I don't know. That still seems like a bit of a stretch to me, but I don't know Minnesota politics on the ground quite as well. So we'll have to keep our eye on what exactly happens there. But it sounds like this political effort to add new gun restrictions in Minnesota is not moving in the direction the governor had hoped for. And in fact, I think he's starting to get some heat from the gun control activists who want him to call the session and I guess just try and push things through despite opposition from Minnesota Republicans.
Yeah, that's right. Every Town for Gun Safety, which is obviously the largest national gun control organization, put out a big press release essentially blasting Tim Walz for taking so long and not actually forcing this thing to go forward and saying kind of let the chips fall where they may, but we want to have this session and we want to see votes on the record. So that's interesting to see, because he's obviously someone that has been supported by them in the past, endorsed by them. They appreciate the fact that he's made gun control a bigger part of his political identity. In fact, when he just announced that he was going to be running for another term of Minnesota governor, he said he plans to make gun control a centerpiece of his campaign. So this is something that he obviously is an issue that he takes very seriously. So to take some heat from the gun control organizations is noteworthy.
Well, and you can see their point here because it suggests to me if they're not even going to do the special session to have the vote, that I guess they think the embarrassment of not passing something is worse than hanging the failure of the bill on Republicans, right? Like, I mean, even if you're sure it's not going to pass, if you thought it was politically popular to back an assault weapons ban, then you'd probably want to do it and force the Republicans to stop you. So it's interesting that he isn't making that calculation, right? Or unless there's something else going on that isn't apparent on the surface, that says something that he doesn't even want to, hang the defeat of this bill on his opponents. Maybe, suggests that maybe it's not as popular as, he's saying publicly.
Yeah, that tells me that there's probably some swing district Democrats probably in his caucus that don't want to take that tough vote either. I've certainly seen that here in my home state of Colorado, where we had assault weapon ban bills fail in successive sessions because, we have a very Democratic controlled state legislature, but even some of those moderate district Democrats did not want anything to do with that bill. And so it never went forward here. So I could very easily see that being the case in a state like Minnesota as well. Yeah,
absolutely. Especially when there's a real possibility that it could pass. Because it's one thing we're going to watch for in Virginia is, if, and the polls indicate that Democrats are doing very well here right now, and the democratically controlled legislature has previously passed a bunch of new gun control bills, but they were all, including an assault weapons ban, but they all failed because the governor, who's Republican, Glenn Youngkin, has vetoed them to this point. And the question becomes, if you get Democratic control of the legislature and the governor's mansion, then will they have the same level of support when it comes to passing these things, if it is still relatively closely divided, because it becomes more politically dangerous to vote for something that is going to pass rather than vote for something that's a symbolic bill, because when something passes, it has a real world effect on actual constituents and could cause them to come out and vote against you. So that's something that is at play in all these political dynamics. So interesting to see what's happening there in Minnesota with this not moving forward at this point.
Yeah, certainly. And then the last story from outside the reload we want to cover today is, we kind of teased it earlier, and that is the lawsuit over the Biden administration's quote unquote engaged in the business rule, which was an ATF rule designed, actually inspired in part by legislation, which makes it a little atypical as far as the Biden administration's regulations go, but from the Bipartisan Safer Communities Act. And this was just essentially to try to get more gun owners who happen to sell some of their firearms from their private collection to have to get a federal license first, become FFLs. And it's a way to try to encourage more background checks being done, because FFLs must conduct background checks before they make their sales. And this is a case that the NRA filed, and the NRA ILA reported that this week they were able to get a permanent injunction against that rule, actually, at the district court level, but it only applies to the NRA, the plaintiffs in the case, and the NRA's members. So Another hole in the Biden administration's gun control rules.
Yeah, and this is one of those rules where we thought we would expect to see a reversal put, another rule rescinding the original rule put up, and that hasn't happened yet. But gun rights activists have had success in court now blocking the rule instead, and they'd had success against pretty much all of these Biden era rules previously, even before the Trump administration came in and has been at least sometimes friendly towards their efforts. Not always. Like I believe in this case, the judge came out and there was an effort by a number of AGs to intervene and defend this rule, arguing that the Trump administration wasn't defending it, or they were worried that they wouldn't defend it, but the judge said there was no need because the administration was defending the rule. But of course, here he sided with the gun rights activists anyway. But yeah, so I mean, practically speaking, the rule, well, I guess if you're an NRA member, the rule, doesn't apply to you. I'd be surprised to see, even though the injunction only covers NRA members, I would be surprised to see ATF going around aggressively enforcing this rule against other people, but just on a practical standpoint. But it is important to note that only applies to people who are NRA members. And I think that the Trump DOJ in other cases has also tried to, the Fifth Circuit silencer case, right, has tried to whittle down who these injunctions actually apply to, even when they are issued for organizations like the NRA. They've been trying to narrow another injunction to say, well, it was only the members at the time that the injunction was issued. So even if you were to join the NRA today, the Trump administration might argue in court that you shouldn't be protected by this injunction. And this goes back, obviously, to the Supreme Court has become extremely skeptical of broad injunctions by the lower courts, especially the district courts. And so this is the result of that. You're in a lot of these cases, it's only going to be the named plaintiffs and organizational plaintiffs like the NRA that get the benefit of these rulings. Like I said, in practice, that might still be something where the government isn't going to aggressively enforce this against other people when they have an injunction on the books but they could, right, legally. So anyway, it's interesting development there. We see, another Biden rule blocked, but not rescinded or undone in the way that President Trump had promised, at least not yet. We could still see that happen, obviously. But it's October now and hasn't been any movement on that front like we've seen with the Commerce Department and its export rule. So
yeah, we'll have to see if they do that or if they decide to do what they did with the pistol brace rule and just say, you know what, we're just not going to defend this in court anymore, and they leave it at that. So that'll be something to watch for sure.
Yeah, we will keep our eye on all of this stuff, especially that Supreme Court case. What gets handed down there is going to have, as we saw this week with the Smith & Wesson fallout from that case, whatever the Supreme Court does, it's going to have a major impact down the line in the lower courts. So, but that is all we've got, right? You got any good plans this weekend? Our teams are playing each other. Right?
I was going to say, I'm looking forward to watching our teams go at it on Sunday. I'm a little nervous because you guys have a pretty good squad over there, but I think, don't count the Broncos out. I think we could shock the world.
The Broncos are a good team, so especially the defense, right? Your defense is one of the best in the league. So that'll be an interesting matchup because I think the Eagles' defense is their strong point too. I am still waiting for the offense to put together a full game, right? Which hopefully that'll happen this week. But they've had like one half of the last two games where they've looked really good on offense, and one half where they've looked like trash. So if they can get it all ironed out and come together and have a full game, I think then we'll start to really see their full potential as a team. But it'll be hard to do against that defense over with the Broncos. Although supposedly PFF, right, said Bo Nix is the worst quarterback.
Yeah, PFF is garbage. Yeah.
Makes a lot of sense, I feel like.
They said he was worse than Jake Browning, the quarterback that he just hung 28 points on, and their offense looked like trash. So who knows with these ratings?
It's been pretty weird sometimes. They put out some weird stats, but yeah, I mean, I hope that we give him a rating that's worse in the league this week. We'll see what happens.
Yeah.
But, and we don't really have any edge rushers, and especially with Nolan Smith back on IR. That's been the weakest point on the defense, is just you're not getting any edge pressure. So hopefully they can turn that around. But Vic Fangio has been really good at adapting and drawing up blitzes that get pressure, and the interior pressure has still been strong. Jordan Davis is maybe the best interior lineman in the league right now, which is wild because he was somebody that I think people thought was a bit of a bust. Not, a total bust, but first round pick. I think he was a pretty high first round pick too. And, but he slimmed down and bulked, got more in shape. And now he returned a blocked kick for like a 80-yard touchdown. So that's on top of he's extremely athletic, and with playing a little lower weight, he's still like 300 and something pounds, but playing at that lower weight has really made him much more dynamic, to the point where I think he's outplaying Jalen Carter's and pretty much everyone else through the first 4 games of the year. So hopefully he can keep that pace up. That's been a nice surprise. He was always more of like a run defender going into this year, and he was good at that, but now he's dynamic in the pass rush too. So excited about that, but got to keep AJ happy. He's always, he's a receiver.
Wide receivers are never happy.
No, he's not TO level, working out in his driveway, holding out nutty stuff, or Antonio Brown. He's certainly not anywhere near the top level drama producers, but hopefully they can make him happy, get him. I'd love to see him, get 10 catches, 115 yards and touchdown or whatever, just to smooth things over. Play buddy ball with Jalen. It's fine with me. Throw it up to him. Certainly the offensive coordinator also is the big question. It's funny because Philly, I got all kinds of complaints about the Eagles and the Phillies. I could throw out all day, but the Eagles are 4-0 after winning the Super Bowl, and the Phillies are the number 2 seed in the NL. But that's classic Philly sports nonsense. There's always something I can pick at, but that's the other thing coming up too, is the divisional round starts on Saturday, so I'm looking forward to that as well. Hopefully the Phillies can put it all together this year and pull off that win before the window closes for good. I think we only got a couple years before that happens. Maybe even team could look real different next year if they don't re-sign Schwarber and JT Realmuto. So they got to pull it out this year. I think they put all our hopes in that basket. But all right, well, that's all we've got for you guys this week. If you want to sign up for our free newsletter, you can head over to reload.com. You can also buy a membership if you want to support the kind of reporting we do here. That is how we fund our efforts. So head over to reload.com and check out those options today. That is all we've got for you this week. We will see you again real soon.